I asked them a direct question. I said, "Do you have any documentation that contradicts the specific claims before this court? Any document, any record, any correspondence?" And they said, "I want you to hear this exactly as it was said." They said, "I dispute the entire jurisdiction of this proceeding." That was the longest pause in 2 hours. The phone was still recording, the red light was still on, and for the first time since this defendant had walked into my courtroom and clamped a tripod to the table and begun narrating a proceeding to an audience that was not present in that room, they had nothing left to say. There is something people believe about courts, that they are theaters, that they respond to performance, that a person who arrives with enough confidence and enough of an audience can shape what a room decides. I have spent 22 years in this building. I sat in the defense chair for 9 of them. I sat in the prosecution chair for 4. And I can tell you from all 3 positions that this belief, however understandable, is wrong in a way that this case made permanent and specific. My name is Catherine Merrill. I am an active state court judge in Detroit. Subscribe and hit the bell, because what I bring to this channel took 22 years and 3 chairs to earn. Tell me this. What did this defendant surrender the moment they set up that tripod? Write it in the comments. I want to know what you saw. What I am about to tell you will change how you understand what happened in that room, because the courtroom's own recording system had been running for 11 minutes and 43 seconds before anyone moved to stop it. There is a timestamp on the courtroom's own recording system, 11 minutes and 43 seconds. That is how long this defendant had been filming before anyone in that room moved to stop it. And I want to tell you why that timestamp is the entire case. I have been in this courthouse for 22 years. I have sat in 3 different chairs in this building, and the thing I can tell you about all 3 of them is that the room itself does not change. The room is the room. It does not adjust for the person standing in it. It does not lower its requirements because the person standing in it has decided, for reasons they have usually thought through carefully, that the requirements do not apply to them. I have watched people arrive in this room with that belief. I have watched it hold for a few minutes, for an hour, sometimes for the first day of a trial, before the room reminds them of what it is. This defendant arrived on a Tuesday morning. The case on the docket was civil, a dispute involving unpaid fees, the kind of matter that moves through in an afternoon when both parties are prepared and present and willing to let the record speak. I had read the file the night before. I do that. My clerks know not to summarize what the summary skips, because the thing that changes a proceeding is almost never in the summary. It is on page 14, or in the attachment nobody indexed correctly, or in the date on a document that does not match the date anyone has been quoting. The file in this case was thin, 11 pages. The underlying matter was not complicated. What I was not prepared for, and I want to be honest about this, because I think honesty about what surprised me is the most useful thing I can offer you, was the equipment. Not the defendant, the equipment. The small, flexible tripod, the kind you can buy for less than $20, clamped to the edge of the courtroom table. The phone already mounted in it, screen facing the room, red light indicating that recording had already begun. I know from the courtroom's own system that this had been running for 11 minutes and 43 seconds before the session was called to order. The defendant did not look at me when I entered. They were looking at the phone. They were speaking to it. Low enough that I could not make out the words from the bench, but with the cadence of someone delivering an introduction, the kind of introduction that has been written and rehearsed and shaped for an audience. The courtroom had a gallery that morning, 3 other parties waiting their turn, 1 attorney, 2 people I assumed were family members of one of the other cases. They were watching the defendant the way you watch someone do something in a public space that you are not sure is allowed. I sat down. I looked at the phone. I looked at the defendant. I thought about the 11 minutes and 43 seconds. I want to tell you what I recognized before that session was called to order. Not who this person was, not their legal theories, which I had not yet heard. I recognized the preparation, the specific quality of someone who had done a great deal of work in advance of this room, and who had done that work for an audience that was not in this room. The tripod was not improvised. The introduction to the phone was not spontaneous. This defendant had prepared, with real effort, for a version of this proceeding that existed somewhere other than the room I was about to call to order. I have spent 9 years on this bench. Before that, 4 years prosecuting cases in this county. Before that, 9 years defending people in this building, in that chair, at that table, with the weight of a case file I had read 3 times on the bus and was about to argue on behalf of someone who was counting on me to know what I was doing. I have been in this room from every angle it has, and in all of those years, in all of those cases, I had not had a defendant arrive with a production setup. What I understood in those first moments, before a word had been said on the record, was that this person was not primarily here to resolve the case. They were here to produce content about resolving the case, or about refusing to resolve it. I was not sure yet which. What I was sure of was that the phone on that tripod represented an audience, and that the audience was, in this defendant's understanding, the constituency that mattered. Not me, not the opposing party, not the record, the people watching. That is the thing I want you to hold while I tell you what happened next, because everything that followed, every procedural choice this defendant made, every argument they offered, every moment where they had an opportunity to change the direction of this proceeding and declined it, everything was shaped by the presence of that phone. And the phone could not help them. The phone was, as it turned out, the most precise documentation of how they chose the outcome they received. The session was called to order. The defendant was asked to state their name for the record. They stated their name. Then they stated their status. They were, they explained, to the phone, not to me, a sovereign national. They did not recognize the jurisdiction of this court. They had prepared documents to that effect and wished to enter them into the record. They produced a folder. Inside the folder were 4 documents: a notice of understanding, a declaration of non-consent to jurisdiction, a uniform commercial code filing, and something they referred to as a certificate of live birth, which they believed established their standing as a sovereign entity under common law. I have seen variations of these documents before. I know their origin. I know the legal framework from which they derive, or believe themselves to derive, and I know why people find that framework compelling. I want to be honest about this because I think it matters. The sovereign citizen belief system does not emerge from nowhere. It emerges in part from genuine experiences of institutions that did not protect people, from genuine encounters with a system that moved against people who had no resources to stop it. I spent 9 years as a public defender in this county, and I sat across tables from people who had every reason to believe that the room they were in was not designed for them. That distrust is not irrational. It has a history. What this framework does with that distrust is something different. It builds from the real injury a legal theory that has no operative effect in any American courtroom, and then it asks people to stake their actual legal situations on that theory. I have watched this happen. I know what it costs the people who do it. I addressed the defendant directly. I told them I had received their documents and would address each of them on the record. I did not dismiss. I engaged. I went through the notice of understanding and explained, with the specific citations the record required, why it had no legal effect in this jurisdiction. I went through the UCC filing and explained the same. The declaration of non-consent to jurisdiction received the same treatment. The certificate of live birth I addressed last, and I want to tell you that my explanation of why it did not establish what the defendant believed it established took approximately 4 minutes, and that during all 4 of those minutes, the defendant was narrating my explanation to the phone. Not to me, to the phone. I stopped mid-sentence. It was not dramatic. It was the specific pause of someone who has decided to name what is happening before continuing. I said, "You are providing live commentary on this proceeding to a recording device while I am speaking to you. You will direct your attention to this court, or I will address the recording device as a separate matter." The defendant looked at me. Then they looked at the phone. Then they said, to the phone, that they had a First Amendment right to record public proceedings, and that they were exercising that right, and that the court's attempt to suppress that recording was itself evidence of the corruption they were documenting. I want to tell you what happened in me in that moment, because I think it is the most honest thing I can offer. It was not anger. I want to be clear about that. What I felt was something closer to a very specific kind of weariness. The weariness of watching someone, in real time, choose the version of this proceeding that was going to hurt them most. The defendant had, at that moment, a proceeding available to them that might have produced a different outcome. The underlying matter was not uncomplicated, but it was not impossible. There was room, if both parties had been willing, for a negotiated resolution. I had seen the file. I knew what the record contained on both sides. That version of the proceeding ended in that moment. Not because I ended it, because the defendant chose the phone. I informed the defendant that the matter of the recording would be addressed. I continued with their documents. I completed my explanation of why each of them failed to establish the legal claims they were designed to establish. Throughout, the defendant provided commentary to their audience, sometimes agreeing with what I had said in a way that suggested they believed I was making their argument for them, sometimes disagreeing in ways that demonstrated they had not followed the reasoning, occasionally announcing to their viewers that what they were watching was historic. Then I moved to the underlying matter. This is the part I have thought about since. Because what I observed when the framework was set aside and the actual substance of the case was before us was that this defendant had not prepared for it. They had prepared extensively. I could see that. I could see the folder, the documents, the rehearsed opening, the setup. But they had prepared for the performance of the sovereign citizen framework. They had not prepared for the case. The opposing party had a single attorney with a file I would describe as unremarkable, clean documentation, the amount owed, the dates, the correspondence, the attempts to resolve the matter before litigation, 12 minutes of presentation, nothing inflammatory, nothing theatrical, the record speaking for itself, the way a record does when the preparation was done properly. The defendant objected to everything. They cited the UCC provisions I had already addressed. They invoked admiralty law, which I want to tell you has not been a viable legal framework in an American civil court for this type of dispute in longer than I have been practicing law. They cited their natural rights. They cited their status as a sovereign national, which I had already addressed. What they did not do was address the documentation, the dates, the amounts, the correspondence. I watched them argue. I took notes. I listened with the same attention I bring to every proceeding because the record requires it and because I have been wrong about cases I thought were simple, and I have learned not to close the file before it closes itself. But I want to tell you what I understood as I listened. I understood that this defendant had built, over some period of time, a complete architecture of belief about what this room was and how it worked. They believed the court was a corporate entity. They believed the judge was a fiction. They believed the proceedings were commerce and that commerce could be refused. They had found in those beliefs a framework that answered every possible outcome. If they won, the framework was vindicated. If they lost, the loss was evidence of the corruption the framework had predicted. The belief was sealed. What the belief could not account for was the documentation on the other side of the table. I asked the defendant directly whether they disputed the amount stated in the opposing party's documentation. They said the amount was irrelevant because this court had no jurisdiction to collect it. I asked whether they disputed the dates of the transactions. They said the transactions were conducted in commerce under their sovereign status and therefore outside the court's authority. I asked whether they had any documentation that contradicted any specific claim in the opposing filing. There was a pause, the longest one in the proceeding. The phone was still recording. The defendant said, "I dispute the entire jurisdiction of this proceeding." I said, "I understand that. I am asking whether you have any documentation that contradicts the specific claims before this court. Any document, any record, any correspondence." They did not. I want to tell you something about that pause and about what followed it. The defendant, for the first time in that proceeding, looked uncertain, not frightened, uncertain. I have sat across from a great many people in this room over 9 years on this bench, and I recognize the specific look of someone who has arrived at the edge of their preparation and found that there is nothing on the other side of it. The folder was empty of what the proceeding required. The framework had everything except the evidence. The defendant asked to make a final statement. I allowed it. What followed was not a legal argument. It was a closing segment, shaped, organized, directed entirely at the phone. The defendant announced the ruling they expected to receive. They characterized this proceeding as evidence of systemic corruption. They told their viewers that what they had just witnessed was the system operating exactly as it was designed to operate, against people like them, in favor of institutions, without accountability. They thanked their viewers for watching. They said they would see them on the other side of this. I let them finish. Then I addressed them. Not their audience, them. I said, "Before I read this ruling, I want you to understand something. What you recorded in this room today is a record of a proceeding that followed the rules this court is required to follow. The documents you presented were addressed on the record, with citations, and found to have no operative legal effect. The underlying matter was presented by both parties. The record in this case is complete. Whatever narrative you construct around what you recorded, that narrative exists alongside the transcript. The transcript is not editable. I am going to tell you now what the transcript shows and what this court rules on the basis of it. There was a quality to the room in that moment that I have only felt a handful of times, the kind of stillness where everyone present understands simultaneously that something is about to become fixed. The other parties in the gallery had been watching for 2 hours. The attorney across from the defendant had his pen down. The bailiff was standing. I ruled on the underlying matter. The defendant owed what the record showed they owed. The judgment was entered. On the matter of the recording and the conduct during proceedings, I entered the appropriate findings. The ruling was delivered without drama because drama was not what the record required. The record required accuracy and completeness, and I gave it those. The defendant said nothing. That is what I had not anticipated. Not the silence itself. I had ruled against defendants who said nothing. It was the quality of this particular silence. The phone was still recording. The light was still red. And the defendant, who had been narrating this proceeding continuously for 2 hours, had nothing to say to their audience. The courtroom does not perform for cameras. That is not a limitation. That is precisely what it is for. The bailiff retrieved the phone per my instruction. I adjourned. I walked back through the door behind the bench, and I thought about what I had just watched, not with satisfaction, because satisfaction is not the right word for a ruling that goes where the record requires, but with something I would describe as the specific clarity of a proceeding that ended where it was supposed to end. I have thought about the gratitude question since, because there was a version of this proceeding that this defendant could have had, a quiet one, an afternoon that resolved a manageable dispute and produced a manageable outcome and sent everyone home. They surrendered that version the moment they clamped the tripod to the table, and I do not think they understood, walking into that room, what they were surrendering. I think they believed that the phone was protection, that the audience was a constituency that the court would have to account for, that documentation would be leverage, that visibility would be safety. The room does not know about the audience. The room knows about the record. What I want you to carry from this is not the collapse. I have said that before, and I mean it. The collapse of a legal theory is not the point of what happened in that room. The point is what the room is. The room that does not adjust to the camera, that does not lower its requirements because someone has set up a production, that reads the record and rules on it, regardless of how many people are watching and regardless of what narrative exists on any platform outside that door. That room exists. It is not perfect. I have sat in 3 chairs in it, and I know every way it fails. I have defended people in it who deserved more than it gave them, prosecuted cases in it where I knew the record was thinner than it should have been, and sat on its bench watching it fall short of what it was supposed to be. I do not describe it to you as a monument. I describe it to you as a room with specific, non-negotiable requirements, and as a room where those requirements, on a Tuesday morning with a thin civil file and a defendant who came to perform, held. The transcript of that proceeding is on record. The ruling is on record. Whatever content exists from the defendant's footage, I do not know how it was edited, how it was presented, what narrative was built around it. That also exists somewhere. Both exist. That is the thing I want you to understand. The room's version and the performance's version both exist now. They will exist alongside each other indefinitely. One of them is the record. The other is the story someone told about the record. If you have ever watched someone treat a shared obligation as optional, as content, as performance, as something that applied to everyone else in the room but not to them, I want to know what that looked like. What room it happened in. What you felt watching someone do the calculation that the rules were for other people. Write it in the comments. I read every one. What you have seen from where you are sitting is part of the picture I can only see from one side of this bench, and I want to know what it looks like from yours. If what you heard today felt like something you have been waiting to hear someone say plainly about what this room is, about what it does and does not bend for, I would be glad to have you here. Subscribe, hit the bell. What I bring to this channel is what I have brought to that bench for 9 years and to the chairs before it for 13. The account of what I actually saw, from the position I actually occupied, with nothing added and nothing softened. The record of this proceeding exists. This case was heard. You were present for it. That is sufficient.